Weiss and Associates presents the U.S. Supreme Court Restrictions on the Federal Income Tax. There are two basic types of taxation options available to the national government, as stated in the U.S. Constitution. The Constitution does not permit the national government to levy an income tax upon American nationals, meaning those who were born in the constitutional republic, the now 50 states of the Union, or upon those who were naturalized therein. Those two types are 1. Excise taxation, sometimes referred to as indirect taxation. This tax is provided to the national government on the manufacturers of selected products such as firearms, ammunition, alcohol, tobacco, and cotton products. The government collects these taxes from the manufacturers, and to recoup their cost, the manufacturers build in the cost of these taxes into each item that they sell to the public. This is a huge source of revenue for the national government. 2. Direct taxation. This one is based on Article 1, Sections 2 and 9 of the U.S. Constitution regarding the rule of apportionment. This tax is a one-time tax and is only levied upon the state legislatures of the 50 states of the Union. It's based on the population total within each state, and then each state legislature determines to levy the tax upon its citizens or not. For this tax to be viable, the national government must adhere to the inclusion of the rule of apportionment, or as stated by the Supreme Court in the Pollock v. Farmers Loan and Trust case in 1895, the avoidance of this requirement makes such an act unconstitutional. The first attempt by the U.S. Congress to levy a federal income tax upon American nationals took place in 1894. A year later, the Congress was challenged in the U.S. Supreme Court on the basis that the federal income tax of 1894 did not include the rule of apportionment. Thus, this act was overturned. This U.S. Supreme Court decision led the U.S. Congress over a decade later to create the 16th Amendment upon the urging by then-President William H. Taft in his letter to Congress, which is the legislative intent of the 16th Amendment, published in the Congressional Record of the U.S. Senate. The 16th Amendment states, "The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration." This is where the U.S. Congress began the use of omission. If you notice, there is no reference to the jurisdiction to which the 16th Amendment is to apply. At first reading, the wording appears to imply that the U.S. Congress has the power and authority to simply disregard any Supreme Court decision, especially the Pollock v. Farmers Loan and Trust decision, ruling that any attempt to impose a direct tax must adhere to the rule of apportionment. For over 100 years, no one seemed to understand that the U.S. Congress was never granted any power to overrule any Supreme Court decision. If it did have such power, then there would be a serious argument about the utility of the Supreme Court. Americans should question the very purpose of the Supreme Court if Congress could simply arbitrarily overturn any of its case decisions. Now you should begin to see that the U.S. Congress does not have such power. There are three branches of government: 1, the executive; 2, the legislative; and 3, the judicial. As noted earlier, there is no discussion in the 16th Amendment as to the jurisdiction for the application of the 16th Amendment. There must be another United States in which the U.S. Constitution is not law in order for the U.S. Congress to legally make such a proclamation. This omission of the jurisdiction to which the 16th Amendment is only applicable within has led Americans to infer that Congress somehow gained authority to act arbitrarily against the Supreme Court. There are actually two United States. The main one that most American nationals are aware of is the Constitutional Republic, the now 50 states of the Union. The Republic and the flag of the Republic is what American nationals pledge allegiance to. The other United States is the territorial jurisdiction of the District of Columbia and its U.S. territories. In this jurisdiction, the U.S. Constitution is not law, and has no legal effect upon the legislation created by the U.S. Congress. Now, the blood is probably draining from your face by now, as this is a true paradigm shift in your comprehension of what you thought you knew for years. In this jurisdiction, there only exists the democracy, which the Greeks proved several thousand years ago does not work well. It's important to recognize that the 16th Amendment does not apply toward American nationals working in the private sector. This is important for you to share with your friends, private sector employers, and others who have a keen respect for the law, and to reject the counterfeit claims that the 16th Amendment applies within the constitutional republic. If you've knowingly or unknowingly granted permission for the national government to treat you like a U.S. taxpayer, you have the option to leave the U.S. tax club on a permanent basis, as provided by the U.S. Congress, by beginning the revocation of election process. This was established so that the national government would not be in violation of the 13th Amendment, which outlaws slavery and involuntary indentured financial servitude. Basically, if you volunteer to be taxed, then it's a choice, not an obligation, much like joining a country club. Subsequent payments as a result of your choice to join become obligatory until you quit the club. We invite you to visit our website, weissparis.com, and email us with any questions. Our email address is bilateral@gmx.com. We have a wealth of free information in our resource center, including links to other shows in our video series. Please smash the like button if you found this video informative and subscribe to our channel. Thanks for watching.